There is one estate planning mistake that turns brothers into enemies, and it splits families that loved each other for over 40 years. And the people who make it almost never know they made it. They think they did everything right. They had a will. They paid a lawyer. They felt protected. Then they died, and then the lawsuit began. In this video, I will explain the single mistake that starts more family estate fights than any other. And by the end of this video, you'll learn exactly how to spot it in your own plan and how to shut the door on it before it ruins the people that you love. All right, let's dive into this one. I'm Santiago Cueto, board-certified international law expert and best-selling author based right here in Miami, Florida. Now, for 3 decades, I've watched families tear themselves apart over estates that looked airtight on paper, and the pattern almost never changes. Now, here's the reason these fights happen. People believe the mistake is not having a plan. That's wrong. The mistake that starts lawsuits is having a plan that is silent in the places that matter most. I call it the silence gap. The silence gap is every question your document leaves unanswered. Who gets the house? Why one child got more than another? What you really meant when you wrote the words personal belongings. When your plan goes quiet, your grieving family fills the silence with suspicion. And suspicion is the fuel that every estate lawsuit runs on. But the silence gap is only the first half of the problem. Most people think there is a magic clause that protects them. It's called a no contest clause. The idea sounds perfect. You write a line into your will that says anyone who challenges this document gets nothing. People sleep better believing that the clause is a force field around their estate. Here's the truth that almost no one in Florida knows. That clause does nothing. Florida is one of the only states in the country that refuses to enforce no contest clauses. Under Florida law, a provision that tries to punish someone for contesting a will is simply unenforceable. That same rule applies to trusts. You can write the clause, but a Florida court will read it and ignore it. So I call that clause the paper tiger. It looks fierce, it has no teeth, and the family that relied on it walks into court completely unprotected. But you might be thinking, then how do I stop a contest at all? Well, stay with me, because the real answer is coming, and it's not what most people expect. Let me show you how the lawsuits actually work, because once you see it, the fix becomes obvious. A disappointed heir cannot win simply because they are angry. In Florida, a will or a trust can be thrown out for specific reasons. Lack of mental capacity when you signed, undue influence meaning someone pressured or manipulated you, fraud, or a document that was not executed the way Florida law requires. Now connect that to the silence gap. Picture an elderly father who quietly leaves more to the daughter who lived with him at the end. He never explained it. He never wrote down why. He just changed the document. To the other children, that silence looks like undue influence. They were not there. They don't understand it, so they sue. And the case is no longer about money. It's about a story, and you left the story blank. Now, if this is already changing how you think about your own plan, do me a quick favor. Hit that like button and subscribe to this channel. I break down Florida estate, business, and family wealth issues every single week so you understand the law before it costs your family everything. Now, let me give you the fix here. The way you prevent a lawsuit is not a scary clause. It's clarity, and it's done while you're alive. Start with what I call the why letter. When your plan treats your children differently, you write down the reason why in plain language. One child got the house because they cared for you. Another already received help with the business. The amounts are different because the circumstances were different. That single explanation removes the mystery that fuels a contest. Next, you build proof of capacity into the moment that you sign. You use an attorney. You sign with proper witnesses. In the right cases, you document that you were clear-minded and acting freely. When the record exists, an undue influence claim collapses before it even begins. And here's the move most people miss. You communicate, not the dollar amounts necessarily, but the structure. When your family hears your wishes from you in your own voice, they cannot later claim someone twisted your arm. The element of surprise is the oxygen of every estate fight. Take the surprise away, and the fire goes out. Now, there is one more layer that wealthy families use, and it's the reason their estates rarely end up in a public court battle. They move assets into a properly drafted and funded trust. A trust contest is harder to launch and easier to manage quietly than a will fight in open probate. So combine a clear trust with a documented reason for every decision, and you have done what the paper tiger clause only pretended to do. You have actually protected your family. But none of it works if the documents are vague, the assets are titled wrong, or the people involved are hearing your wishes for the first time at the funeral. This is the silence gap, and it is entirely preventable. So let's bring this all home. The mistake that starts family lawsuits is not the absence of a plan, it's a plan that stays silent where your family needs an answer, paired with a false belief that a no contest clause will save you. In Florida, that clause is a paper tiger. Your real protection is clarity, proof, and a conversation. The families who do this never end up in my office fighting each other. The families who skip it spend years and fortunes in court, and they rarely speak again afterwards. The choice is yours, and you get to make it now. Now, if this video helped you see a gap in your own plan, hit that like button and subscribe to this channel so you never miss a new video. Share it with a family member who needs to hear it, and drop your questions in the comment below. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.